Welcome back to T.L.C. Cares. My name is Jolene Cicchese, and I'm a registered nurse with T.L.C. Private Home Care located in Buzzards Bay and Chatham and Hingham. And today I have attorney Kathryn Bean from Bean and O'Connor right here in Bourne. She likes to be called Katie. Hi Katie, welcome.
Hi. Thank you for having me.
So Katie is an estate lawyer, and today we're going to talk about wills, trusts, and what we need to do. So Katie, why do I need a will?
So you need a will basically to scoop up all your assets, give some direction to people that you're leaving behind items to. It's a really great way to get yourself organized and make sure assets that you have go to the intended people. You never want to not have a will, because if you don't, then you're at the mercy of the court to make some decisions.
So what goes in the will? Like what? Like my house or my...
Sure.
My bicycle? No, just kidding.
No, that's okay. So things like bicycles, if you had a china cabinet, you had a diamond ring, something of that nature, you would usually do that in what they call a side memo. So the wills come out very basic. It tells you who the intended beneficiaries are. It tells you who's going to have the right to act on your estate. So the old language used to be executor. Now when you come to see me or any other estate planner, it's going to be personal representative. So it's a little bit of a mouthful, but it has changed. So typically if people hear executor, administrator, it's now personal representative.
So that personal representative is the one that's going to, you'll read the will to?
So that is the person that actually goes to the court and files the will with the court and says, I need to be appointed to act on part of the estate. So what people don't understand is a lot of times if there's bank accounts, your house, things like that, a personal representative has to be appointed. So I do point out the very quick caveat that when you do an estate plan, you're going to do a power of attorney. Power of attorney actually goes away upon the death of a decedent. So people will show up to a bank and go, I've got a power of attorney, and they've got a death certificate. And the bank says, nope, sorry, you're now at the probate court. So it's very, very simple if you have a will to get through the probate court. It takes about 8 weeks. If you don't have a will, you can still get through okay, but it's so much more organized.
8 weeks, that seems like a long time.
It's actually very short. So Barnstable County is about 8 weeks with citations, and so citations are things that the court gives the attorneys to say where to publish, who to give notice to. That could be the heirs at law. It could be devisees. So the difference between an heir and a devisee in a will is that an heir is somebody who's related to you, and a devisee is somebody or sibling, could be a parent, could be a cousin, depending on if you have children, if you're married. And then a devisee is actually somebody that's named directly in the will. So that could be a child, but that could be your best friend that you're leaving your cat to.
So who gets in touch with, or does the personal representative, is that what it is? Executive, whatever. Who does that person have to get in touch with? You?
Yes. So usually, generally what happens, a death occurs, and then the personal representative would call us. So in the event there's no will, then we have to basically start going through pieces to say who actually has the priority of appointment. So that's under like a general statute. Versus you have a will, it's direct. We just get going right on the paperwork. So instead of maybe being in the court 10 weeks or waiting 10 weeks to start probate, we're in there right away because we've got the will and we've got the personal representative named.
Does that personal representative have to go to court with you?
No, they do not. So the big misnomer too is that once you have a will and you go to probate, the attorney basically takes over, does all the paperwork. Things have actually changed to digital signatures now too. So you actually sometimes don't even have to be present with the attorney. You can do Zoom calls, you can pick up the phone. You obviously, of course, can always come in to the office. I love to see people face to face too. But I do like to let people know it is streamlined. And as soon as you've got that will in place, then again, you would call us, we would do the paperwork. We would either have you come in to sign personally, or we would send it through like DocuSign. And then everything actually gets electronically filed. Everything gets electronically filed at the court too. So there's not even any more of the attorneys going in. We overnight the original will to the courthouse, and then everything gets electronically uploaded.
All right. Is that the will part of the estate plan?
Yes. So basic estate plan that everybody needs is a will, healthcare proxy, so that is the directive to a fiduciary or a named person to make medical decisions.
Right. I tell everybody, make sure you have a healthcare proxy.
Yes, yep, and then when you do get up in age too, we want like the MOLST form, so yep. That's something that a doctor can get into with clients.
A MOLST form means that you do not resuscitate, do not hospitalize, or do not intubate.
Yes, correct.
So.
And if you're, I love to see people have those because I think they're a great direction for your healthcare proxy. It's the recipe card that tells the healthcare proxy, and especially in cases if there's people out there that are single, that do not have spouses, don't have children, don't have somebody close to them.
We tell them to put that up right on the refrigerator, because if you end up calling 911, they're going to come in, they're going to look for that.
Yes, and it's bright pink, as you know.
Yep.
So yes, I always say to everybody, if you can get that, and that's doctor driven, so you have to advocate for yourself at a doctor's appointment to make sure you get those forms.
Okay.
But that kind of goes hand in hand. It's not part of like my package, but I do discuss it with people to make sure they know it's important and that it should go with the healthcare proxy.
Yeah.
The other two documents that go in the basic estate plan are a HIPAA form, so just the right to medical records.
Okay.
So every time you go in the doctor, everybody signs. They will keep the medical information private, so this gives somebody in your event of incapacitation the right to look at the medical records.
Yeah, perfect.
And then the last one is power of attorney. So power of attorney is a living document, so like I said again, it's good while the person is alive.
So that's part of the will though, right?
Nope, so the will is standalone, so the will really comes into play upon the death. So you're never going to really need the will until the death has occurred. Power of attorney is your living power, so that's the right to do the banking. It's a right if somebody had to go into a nursing home to be able to sign papers of that nature. If somebody got so incapacitated and they had a house to dispose of, they could use a power of attorney to sign a deed.
Okay.
So that's really kind of a big piece.
What about, let's talk the real estate part now. You have a house and you have a second marriage and there's like 5 kids between the two of you.
Yeah.
What happens if I go before like my husband, or does that part of my house in the future, it'll stay with my husband, but what happens if the two of us pass away together and we both have different wills? Does the house...
So if you had different wills, it would depend who would actually have been deemed to have passed first. So it's very rare that they can't determine that.
Right.
So it would probably be the last person would be the triggering will. So what I tell people, if you have blended families, or even if you don't have blended families, but you have specific stipulations on real estate, is that you may want to utilize a trust. And there are numerous types of trusts, so it's very indicative of what the actual family situation is.
Okay.
So I do tell people, come armed when you go to see an estate planner with what those intricacies are, because then an estate planner can say to you, this trust fits your needs. And I will say with trusts, they're not for everybody. They don't fit every single mold. But I think the one biggest thing that everybody hears about, and if you look it up, on any sort of website engine, is that if you are in a trust, you're going to avoid probate, which is completely true. So then the real estate, which is usually your biggest asset, doesn't go to the probate court. So that way, the biggest thing when you're talking to an estate planner is to figure out how can we keep the most, or go in with the least amount to the probate court. So there's different tiers at the probate court. So the biggest goal is to get you to what they call a voluntary administration, which is a basic probate. So it's a few weeks to process, and it's only a few $100s. So people really like that.
Well, I think that's a big thing too. People don't do their wills, they don't do their estate plan because it's costly. But I was surprised when you told me the cost of a will wasn't as much as I thought.
Yes.
So a simple will, what are we looking for cost?
So for a simple will that includes those 4 core documents, which is the will, healthcare proxy, power of attorney, and HIPAA, is a flat fee of $700 per person.
And that's amazing.
Yes.
That is amazing, because I've heard upwards of $3,500 and things like that. So
well, I think sometimes those are when people overcomplicate estates, and I think that's a really big thing, understanding what your goals are and having a really good, talk with your practitioner. This is what I need, try not to go in and be sold all sorts of different things that you may not need. We're in a very changing society. The other piece is when you do your will, you really should pull it out every 3 years. Am I good? We actually just went through a whole thing at my office because my partner retired, and I have people's wills from 1989.
Wow.
And but they didn't have to be changed.
Okay.
They were wills that were still in great working condition, and the people had pulled them out. We reached out and they said, yep, we're good. And I said, okay, wonderful. I don't see anything that we need to update. Sometimes there are things that need to be updated because life changes, or could be like the personal representative you've named in your will. Maybe you're no longer close with that person.
Right.
Maybe they've become deceased.
So updating it and looking at it every 3 years.
Every 3 years.
Okay.
And
who needs a will? Everyone?
everybody. Everybody.
What if you have no assets?
So if you have no assets, you still need a will, because even though you think you may not have assets, there could be something that's just out there that gets forgotten, a bank account. Because if you don't have somebody named on your bank account, then you have to go through probate. So everybody should have a will to scoop up no matter what. I think for the short money, and I will say too, many practitioners, maybe you're going in and you're saying, I don't need the full estate plan. I don't need all those 4 documents. I have a lot of people that have healthcare proxies.
Right.
So when they come in, I look at their healthcare proxy and say, if this is good for you, then let's back that out of the cost basis.
It's one of the most important things.
It is.
You know, coming from the medical field, and we see it all the time, people don't have the healthcare proxy, and we can't give information unless we get permission, and that document is vital.
And I will say the difference between a healthcare proxy that's done with an attorney versus one that you're going to do at a hospital, because anytime you go in for a procedure at the hospital, if you don't have one, they make you do one.
Right, exactly.
So, you know, which is great. It's fine. It's good. It's out there. There are certain people that get really intricate on their healthcare proxies, though. They look and say, I don't want just a physician that's on staff at the ER making a call on whether I'm in a vegetative state. I may want my primary care to do that for me.
Because the primary knows you much better.
Yes.
I mean, you've developed a relationship and been in there. And
so our healthcare proxies really go in depth with those. If
Okay.
that's like a really specific wish. There are some people that really know medical, you know, backgrounds. So they say, if I get to a certain point, I don't want water, or I want different things. So the healthcare proxies we do are more like a 5-6 page, because it kind of really gets into your healthcare versus just
That's
a
perfect.
white, you know, 1 page. So it's very indicative again of what the needs are. Some people are very happy with a 1 page, and sometimes that does the trick. There's other people that want to be very involved in their healthcare decisions and making sure that the people that they're placing to make those decisions understand what they want.
Right, and you got to have those tough conversations with your partner or your oldest child, or whoever you name as that healthcare proxy. You have to let them know what your wishes are, because you know, if you're in a vegetative state, or even if you're on hospice, how fast do you want, you know?
Yes.
Stop feeding me, stop giving me water. I don't want to be in this state. Like, you have to make your needs known.
Yes.
So.
And I think that's why the MOLST form is important too, because it gives those directions, and again can be held hand in hand with, you know, the healthcare proxy, either one at the hospital or the ones that we would do. And I think the other big piece, when we were just talking about wills and why people need them, is I have a lot of people that come to me and they say, I've got, you know, my husband and I've got my children and they all get along and everything's going to be sunshine.
Yeah.
And I have to remind people that we're looking at today's date, and we're not looking into the future, because we don't know what the future holds. But we always forget that we may have a child that ends up, you know, unfortunately with a drug problem, or they may end up with a spouse that comes in and starts pushing around different, you know, views. So it's really important, if you want to protect your assets, to do that will and make it set in stone. Otherwise, it's a guessing game for the court. And it's a lot harder to object to a will versus somebody who dies intestate and you have just heirs coming through and objecting.
Oh, we see it even when the patient is alive. You know, the families say I want this for mom, no, I want that for mom.
Yes.
Well, who's the healthcare proxy, you know, and that's what it comes down to. Or who's named first and then who's named second. Well,
and that's another good point, is I usually have that conversation. Who do you want first? Who do you want second? If you're going to do more than one, you know, fiduciary, do they need to act together? Can they act independently? So I think those are tough conversations that families have to have, and explaining, you know, why mom or dad or whoever it may be want those decisions.
Now I have a question for you. What if you have minor children? You have to put in a will who's going to take those children?
Yes, so there's usually 2 prongs to that. So my usual conversation is, do you have a guardian set up? So that's somebody who would take care of the child, versus most times we build a trust into the will, which says someone who would manage money. So sometimes that's not the same person. Sometimes
Right.
you've got somebody you want to raise your children, but you don't think that they're good with money. So you establish like a trust for them to basically be spent down over time.
So like an allowance.
Yeah, well, almost, yeah. So it's almost
Yeah.
an allowance. There's triggering usually ages. So usually it's 25, 30, 35. Because as we know, people are getting married a little bit later in life
Right.
now, responsibilities. But the trustees do have quite a bit of flexibility. So if a child wanted to go to college, they could disperse some of that
Okay.
prior to. If there's health concerns and they need
Yeah.
that money to take care of them, health-wise,
Yeah.
then those distributions could come before triggering age requirements.
I think that is one of the most important things. If you have minor children, you need a will.
Yes, and I will caveat on power of attorneys too. If you have children that turn 18, make sure they get a power of attorney. You can make medical decisions for them after 18, by your degree of kinship.
Yep.
But being able to access any bank accounts and items like that, you would have to
Oh.
go to a court. So I tell a lot of people, if your kids are just turning 18, they're staying local. But if they're going to college and they're
Right.
going to be out of state, very super important.
Okay.
Simple document that they can get done. They don't have to have a whole estate plan.
Can they
but
do
at least
that over the phone and Zoom with you?
So that they would have to actually physically see a notary at some point,
Okay.
but you could do the initial appointments through a Zoom call and those items, and if the child's already out of state, they would
Yeah.
just go see a notary in their state to sign off on the document.
Okay.
So it is able to be done logistically.
Okay. It all seems very easy talking to you. Most people think it's, oh my God, it's so difficult, it's going
Yes.
to take a long time, or
Yeah.
I don't know what to do, what's the best thing. You kind of made it really
Yeah.
easy to understand, and
And it's morbid too. A lot of people don't like
I
to come
know.
in.
I know, I know.
It's not a fun
Yeah.
conversation.
I know, yeah.
But it is easy, and I have a lot more people walk out of my office and say,
Wow.
wow, that wasn't so
Yeah.
bad. And sometimes when the initial appointment happens, I give a very long questionnaire, and everybody hates it. I will tell you right off the bat. But every estate planner is going to give it to clients. It's to
Okay.
really dig deep to figure out what you have and what can avoid probate.
Yeah.
It's to get you organized. It's your roadmap.
That's so good, so important.
Yeah.
Yeah.
So it's usually when a death occurs, people don't know where to look. So that little questionnaire is helpful.
Right. Well, thank you. I really appreciate it, Katie. This has been eye-opening. Thank you for coming. It's Katie Bean from Bean and O'Connor, attorney Katie Bean, right here in Bourne. And I'm Jolene Cicchese from T.L.C. Private Home Care. If you have any questions related to any of this, you can call Katie at Bean and O'Connor, or you can call me over at T.L.C. Private Home Care. Again, thank you for coming, thank you for watching, and we'll see you next time. Take care.